Well, howdy, y'all. Welcome to Uncivil Law. I hope you're having a great day as always. And we are here with Supreme Court awesome law done quick. Where is Tulsa, Oklahoma? Is it in Oklahoma or not? I don't know. We're going to find out. So we are doing that whole thing today, starting in about 9 minutes. I think we have 7 opinions, and I think we're getting them all today. And let me see if I can find a list of the opinions that we are expecting to come down today. I think this is the last day of the term. Then again, I thought the last day of June was the last day of the term. So who knows? What opinions are we going to get today? I don't know. Maybe we'll get one. Maybe we won't get any. Maybe it's a whole tease. Maybe they said we're going to announce decisions today, and then they come and be like, yeah, we don't have any decisions. Meh. So we might get some decisions, we might not. We might get them all. We might get none. Who knows? These are the questions that we do in law world. It could be some number of things. Yeah. So we are doing all that great stuff, and I'm trying to find a list of the things in that are still pending. Yeah. I know there's the Faithless Electors case, whether or not a elector for the Electoral College can be forced to cast a vote in the Electoral College in a particular way. There's the Where's Tulsa, and there's some other stuff. So we will see. I can't find a list right now. Yeah, the camera is mounted to my monitor, so which is attached to my desk. So every time I shake the desk, it shakes a little. Theoretically, the lens is supposed to have steady shot, so theoretically it's supposed to reduce the impact of the shaking. But eh. Oh yeah, the issue the Where is Tulsa is actually kind of a joke. It's tongue in cheek, but the issue is technically whether or not half. Well, it's not even technically whether or not half. The implication is for half, but it is whether or not a chunk of Oklahoma is actually Indian tribal land. That's the real issue. So we use the Where is Tulsa as a sort of tongue in cheek way to summarize the issue, because the issue is part of Oklahoma and ultimately half of Oklahoma Indian tribal land or not? That's the operative question. And we are suspecting the vote is 5-4. The reason we're suspecting that is because last term they had the exact same issue in a different case. And they said, oh, we're not going to decide the issue. We're going to order re-argument. And then they never had re-argument, incidentally. And the reason that they did that, reading between the lines, is because Justice Gorsuch was recused, because he sat as a judge in the 10th Circuit when that case was coming up. I don't know if he touched it or not, but it doesn't matter, really. So anyways, he recused himself, and the Supreme Court said, oh, we're not going to decide this case. We're going to order re-argument, and then didn't do that, and instead ordered argument in an entirely different case, which raises the exact same legal issue, but percolated during a time when Justice Gorsuch wasn't recused. And so the implication, therefore, would be that the Supreme Court was tied 4-4. Because if it was anything other than that, if it was 5-3 or 6-2 or whatever, then they would just issue the opinion, right? But if it's 4-4, then it's like, well, let's give it another go. So this is the only real difference is that Justice Gorsuch was able to hear the case. That's the only legal difference. It's the exact same legal issue. You wouldn't expect it to come out differently in one case versus the other, but it's a very technical reason that Justice Gorsuch was able to hear this one, not the last one, even though it's literally basically the same case. So it's just one of those little weird things in law. So we're expecting it to be 5-4 because nothing else would really make any sense. And so all eyes are on Justice Gorsuch and which way is he going to go on the where is half of Oklahoma case. Now, I have said, and I am by no means an expert in this area of law. So some areas of law I know more than other areas of law. In some areas I'm more willing to, flex my expertise than other areas, which hopefully is a way for you to know that I'm not BSing when I say things with more authority, right? If I'm willing to say, oh, this is something I don't know as well, maybe you'll take me more seriously when I say this is something I know more well, right? So when it comes to Indian tribal, this is an area where I don't know as well. So my very limited understanding Here's my very limited understanding of the legal posture. All right. Congress can eliminate a tribal claim. All right. Because Congress can like basically recognize and de-recognize entire countries for that matter. And so can the president for that matter. It can just like de-recognize. So like what are valid countries and what are not? As far as the United States is concerned, is the United States call. Now other countries might be very grumpy whether or not we recognize them or not. But that's, a different problem for a different situation. So we can just like, not recognize countries. That's an option. And so Congress can not recognize countries. They can say no, no, that's not a place. That is not a place that exists. And so they can abrogate any claim basically, and they can abrogate these Indian tribal claims. They can say no, you're not a thing that exists. We do not recognize your claim. There might have been treaties or whatever, but those are all super interesting and all, but enforce the treaties. Oh, that's right, you can't because we're bigger. So, big stick diplomacy. Anyways, hold on a second. But here's the catch. Congress has to actually do that. And they have to do it explicitly. They have to do it directly, and they have to do it clearly and unambiguously. And so all these words should give you a clue as to the issue. Did Congress actually do that? And the answer seems to be no. Congress didn't actually do that. They did a lot of other things. They gave away all the land in a process called apportionment. So they redivided all the land and they gave it all away. So they took the land away. I don't think they I can't remember if they abrogated the tribe or not. I don't think they did. They took away all the tribe's power. So they removed all the power of the tribe, but I don't think they actually like formally extinguished the tribe. So the tribe like formally exists, even though it has absolutely no power to do anything, and even though it has absolutely no land. But Congress never actually, this is the debate, right? Congress never actually took that last final step of saying, no, you're not a thing that exists. So it may continue to exist. And then, of course, the question after that is, does it matter? And that's a question that at least I can't figure out the answer to. Does it matter or not? I don't know. It matters to the person who is it matters to this particular person, presumably, because they have been subject. So the person that is at the root of this case, it matters to potentially quite a lot. And it would matter also to criminal cases going back 100 years, because here's the trick. If it's an Indian, if it's a Native American, and they commit a crime on tribal land against another Indian, then the federal courts have exclusive jurisdiction, not state courts. And so the person who's at the root of this case was convicted by a state court of murder and sentenced to the death penalty. So it matters quite a lot to him because, if the state court never had jurisdiction in the first place, because he is a member of this tribe, so it goes. And the person he injured is a member of this tribe, so it goes. And it occurred on what would be Indian land, so it goes. So if all those things are true, then the state court never had power to try him. And so the whole thing is presumably void ab initio, and only the federal court could try him. So it matters quite a lot to him and his potential criminal liability. So yeah, these are the issues in place. So there's a very esoteric issue of where's half of Oklahoma and does it matter? And then the much more real issue of does it matter to this particular individual who may be a Native American of what may be a tribal land, who may have killed another Native American, and therefore may have only been able to be tried by a federal court, not a state court, and therefore his entire conviction is void. Fun times. There are many, many issues. And it is 10 o'clock, so we have to switch to the feed. And we're doing Awesome Law Awesome Law Done Quick. Well, it may have not been death penalty. Maybe the other one was the death penalty. There were two, because there were two of them, right? So maybe one of them was death penalty and one of them was 1,000-year sentence. I don't remember. But either way, it matters a lot. So yeah, maybe one of them was death penalty, maybe the other wasn't. So yeah, I forget which is which. Not that it totally matters that much when you're talking about 1,000-year prison sentence, but whatever. $2 from TornyNet because it's Monday. Thank you. So we are doing awesome law done quick. As always, we are going to speed read. Our goal, because they announce these things about 10 minutes apart, my goal is to read them, understand them, explain them in under 10 minutes. That should go over really well if we have the Oklahoma decision. We're gonna probably have to give that another read. Me. Ooh, darling, please don't go. Don't. Yeah, so he wouldn't. There wouldn't be a double jeopardy problem, because the state and federal courts have different jurisdictions. So he would be able to be tried again in federal court. There was a case term ago or 2 terms ago about that. But long story short, yes, he could be tried in the federal court. So that isn't a problem. And we have a decision from Justice Kavanaugh. Again, these are announced in reverse seniority order, and Kavanaugh is the most junior judge. So that might give us an indication that we're here for a little bit. Because I think we're expecting 7 decisions and there's 9 justices, right? So we're starting with the most junior because that's how we do it. They're issued, that's how you want to know, they're issued in reverse order of seniority. So we have a link, and we are going to speed read this and speed understand it. Let's get started. All right, so this is Barr versus some other people. In response to, okay, this deals with whether the government, this deals with robocalls. The government made robocalls illegal for debt collection purposes, except for government loans. So the issue is the constitutionality of that. My prediction is it is constitutional. The U.S. government can regulate this because it is a commercial speech. It is in the nature of commercial speech. Buy this, sell this, give me money. So it is commercial speech. Government can regulate it. Government can exempt itself. It does not raise an equal protection problem. So my prediction is U.S. government wins. All right, let's see if I'm right. In response to consumer complaints, Congress passed the Telephone Consumer Protection Act of 1991 to prohibit, among other things, almost all robocalls to cell phones. In 2015, Congress amended the robocall restriction, carving out a new government debt exception that allows robocalls to be made solely to collect a debt owed or guaranteed to the United States. The American Association of Political Consultants and 3 other organizations that participate in the political system filed declaratory judgment action claiming it violated the First Amendment. No, because it regulates commercial speech, and no problem. And also, it's the person I think it's fine. The district court determined the robocall restriction with the government debt exception was content-based, but survived strict scrutiny because of the government's compelling interest in compelling debt. Sure. The Fourth Circuit vacated the judgment, agreeing the robocall restriction with the government debt exception was content-based, but holding it could not withstand strict scrutiny. The court invalidated the government debt exception. The judgment is affirmed. Okay, so I was wrong. It went the other way. It's a content-based restriction. Some debt collection is okay. We're doing it based on the nature of that content. Strict scrutiny, we can't make strict scrutiny. So I had the wrong analysis because we allowed some debt collection calls, not other. We're doing it based. So if it had applied to all debt collection calls, it would have been fine. But because we did it specifically for government protect calls specifically, that makes it content based. So we elevate from intermediate scrutiny to strict scrutiny, and we can't pass strict scrutiny. Okay, that makes total sense. I'm 100% on board with the decision. Makes total logical sense. I just predicted it wrong. So I now understand it and I can explain it. Okay, the judgment is affirmed. The free speech clause provides the government has no power to restrict because of message, its ideas, or subject matter or content. Under this court's precedent, content-based laws are subject to strict scrutiny. The law's robocall restriction with government debt exception is content-based because it favors speech made for the purpose of collecting debt over political and other speech. The government's arguments for deeming the statute content neutral are persuasive. First, it does not draw a distinction based on speakers, and even if it did, that would not automatically render it a content neutral. Second, the law here focused on whether the caller is speaking about a particular topic and not, as the government contends, simply about whether the caller is engaged in particular economic activity. Okay. Third, that seems like not as great a reasoning to me right there. I don't quite buy that part of the argument, but not that matters. Third, while the First Amendment does not prevent restrictions directed at commerce or conduct from imposing incidental burdens on speech, the law does not simply have an effect on speech, but it's directed at certain content and is aimed at particular speakers. As the government concedes, the robocall restrictions with government debt exception cannot satisfy strict scrutiny. The government has not sufficiently justified the differentiation between government direct calls and other important calls, such as political speech and blah, 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 whatever. And then we have some other people opining about some other stuff, and some people opining about some other stuff, and people opining some other stuff. And that's the end of that case, so that's it. And that looks like that's dead. So, what is the implication of that? Anyone can make robocalls for any reason at this point? Is that the implication of that? That seems to be the implication based on the syllabus, that anyone can make. So maybe we will all be getting way more robocalls than we did before, because it looks like clause not apply, presumption of severability, remainder. Okay, so we had three people. It's part of the Communication Act. The clause did not apply. The presumption of severability, the remaining law is capable of functioning. Reading the scenario exception fully cures the. Okay, so three people wouldn't sever it. No. So the Supreme Court. Wait. No. Wait. Because I'm trying to figure. Now I have to figure out what the narrowest grounds are. Hold on, because I have to figure out what the narrowest grounds of this are. So now I have to count votes. Fun. All right. So Kavanaugh, Chief Justice, Thomas, and Alito. Okay, so that's only four anyway. So four apparently want to kill the whole thing. Oh my God. Three say, Jesus Christ, counting votes is annoying. Sotomayor concluded the government debt exception falls under inmate scrutiny as severable. Justice Breyer, that's a fourth vote. So, okay. Okay. All right. If I'm correctly counting votes in my head correctly, as I'm trying to desperately count to 5, I have to massively revise pretty much everything I said. Okay. So I have to massively revise everything I said. Okay. So it's intermediate scrutiny, not strict scrutiny, because that's the narrowest grounds, if I'm counting correctly. And it's severable. So Sotomayor wins. It's intermediate scrutiny, but it's severable. So it doesn't pass intermediate scrutiny, it's severable. So only that provision dies. So robocalls are still illegal, I think, if I correctly counted votes. Fun. Let's go back to the main thing. I think I counted votes in that correctly. Yeah, because 4 people said, oh, it's strict scrutiny, but that's 4 votes. And then 3 people said it's strict scrutiny, but it's sufferable, but that's only 3 votes. And then Sotomayor comes in with the 5th vote. So that's the 5th vote, right? And so now looking at the narrowest common ground, what is the narrowest common ground? Well, Sotomayor is the narrowest common ground. So Sotomayor may not have written it, but Sotomayor's opinion is controlling because it's the narrowest common ground. So therefore, it's intermediate scrutiny. It doesn't pass intermediate scrutiny. It's severable, and the rest of the thing survives. I think, if I counted votes correctly. How fun. The last paragraph sums it up nicely. Congress created a general restriction on robocalls to cell phones, but carved out an exception. The exception is unconstitutional. The court fixed the problem by separating from the rest of the statute. So all robocalls are unconstitutional again. I don't know if that's correct or not. I know that the person says it, and this person should probably be listened to, but I'm not 100% sure that's correct. I'm not sure that all robocalls are unconstitutional. They did sever it, but I'm not sure what exactly they severed, and I have to go count votes. So, yeah. So, Justice Kavanaugh wrote the opinion, but I think Justice Sotomayor's opinion is the one that's controlling. So, yeah, that's we will figure out whether all robocalls are illegal or not. So, can people engage in robocalls? I don't know. What is the standard of review? Is it strict scrutiny or intermediate scrutiny? I don't know. So I'm not sure how much more educated we were than when we started, but that's awesome law done quick for you. The exclusion is illegal though, so it can't be just that. So something has changed. Yeah, the robocalls themselves would not be unconstitutional. The restriction would be unconstitutional. So yeah, the robocalls themselves would not have been unconstitutional. They would have been illegal. So are they legal now? I don't know. Maybe something's legal. The restriction was illegal. So then it becomes a question of, what does that mean? Does that mean that like all debt collection calls from everyone is legal? Does it mean that all robocalls are legal? I don't know. What is the standard review? I'm not 100% sure because it was a fractured opinion, and I have to count votes. Okay, so we have the Faithless Electors thing. My prediction here is that yes, the states can force the electors to vote a particular way in the Electoral College. They can punish them. They can criminally sanction them. They can require them to vote a particular way. Let's find out if I'm right about that. Do I have to count votes on this one? Let's find out. All right. So the question is, can a state force a person to vote a particular way in the Electoral College? That's the question. My prediction is yes, they can. Let's see if I'm right. I'm not even sure if I was right on the last one or not. Was I right the last time or not? I don't even know because I'm still trying to count votes. Was I right? I don't even know. Let's find if I'm right about this one. Okay. When Americans cast their ballot for presidential candidates, their vote actually go to selecting members of the Electoral College, who each state appoints based on popular returns. Yes, when you vote for president, you're not really voting for president. That's right. The states have devised mechanisms to ensure the electors they appoint vote for the presidential candidates their citizens have preferred. With two partial exceptions, every state appoints a slate of electors selected by the political party whose candidate has won the state's popular vote. The exceptions, by the way, would be Maine and Nebraska, for those of you playing at home, who also give votes based on congressional district, but whatever. Most states also compel their electors to pledge to support the nominee of the party that won. Relevant here, 15 states back up their pledge with some kind of sanction, monetary fine, whatever. Almost all these states immediately remove a so-called faithless elector from the position, substituting an alternate who votes as the state reports insist. So the state will remove you and make you vote a particular way. A few states impose a monetary fine on any elector who flouts the pledge. 3 Washington electors, whose names don't matter, violated their pledge to support Hillary Clinton in the 2016 election. In response, the state, and incidentally, they didn't vote for Donald Trump, they voted for like other random people, in fact, like Colin Powell or whatever, but it doesn't matter. In response, the state fined the electors $1,000 apiece for breaking their pledges to support the same candidate the voters had. The electors challenged their fine in state court, arguing that the Constitution gives members of the Electoral College the right to vote however they please. The Washington Superior Court rejected that claim, and the state Supreme Court affirmed, relying on Ray versus Blair. In Ray, this court upheld a pledge requirement, though one without a penalty to back it up. Ray held that pledges are consistent with the Constitution's text and our nation's history, but reserved the question of whether a state can enforce the requirement through legal sanctions. I say yes. Held. A state may enforce an elector's pledge to support its primary nomination of the state's choice for president. Got one right. Got one right. So we're one and maybe a half. I don't know. But I got this one right. Article 2, Section 1 of the U.S. Constitution gives states the authorities to appoint electors in such manner as the legislature therefore may direct. This court has described the clause as conveying the broadest power of determination over who becomes an elector, and the power to appoint an elector in any manner includes the power to condition the appointment absent some other constitutional constraint. A state can require, for example, that an elector live in the state or qualify as a regular voter during the relevant time period. Or more substantively, a state can insist, as Ray allowed, that an elector pledge to cast an electoral college ballot for his presidential nominee, thus tracking the state's popular vote. Or, so long as nothing else in the Constitution poses an obstacle, a state can add an associated condition of appointment. It can demand the elector actually live up to the pledge on pain of penalty, which is to say the state's appointment power, barring some other outside constraint, enables the enforcement of a pledge like that of Washington's, or jail time, or whatever. Nothing in the Constitution expressly prohibits the state from taking away a presidential elector's voting discretion, as Washington does. Article 2 includes only the instruction to each state to appoint electors, and the 12th Amendment sets only out the process of voting. And while 2 contemporaneous state constitutions incorporated language calling for the exercise of electoral discretion, no language of that kind made into the federal Constitution. Contrary to the elector's arguments, Article 2 uses the term elector. The 12th Amendment requires that the electors vote, and they do so by ballot. It does not establish the electors must have discretion. The electors and their amici object that the framers using those words expected the electors' vote to reflect their own judgments, not necessarily those of anyone else, but whatever they think. But even assuming that was the outlook, Even assuming that was the outlook that was widely shared, it would not be enough. Whether by choice or accident, the framers did not reduce their thoughts about electors' discretion to the printed page. Long and settled established practice may have great weight in a proper interpretation of constitutional provision. The electors make the appeal that to that kind of practice in asserting their right of independence, but our whole experience as a nation points in the opposite direction. From the first electors under the Constitution, states sent out electors to the college to vote for pre-selected candidates rather than using their own judgment. The electors rapidly settled into a non-discretionary role. Ratified at the start of the 19th century, the 12th Amendment both acknowledged and facilitated the Electoral College emergence as a mechanism not for deliberation, but for a party line, or, more to the point, directed voting. Courts and commentators throughout the century recognized presidential electors as merely acting on other people's precedents. In other words, it's ministerial. It is not something that you have discretion for. And state electors evolved to reinforce that development, ensuring that state electors will vote the same way as its citizens. Washington law is only another along these same lines. It reflects a long-standing tradition in which electors are not free agents. They are to vote for the candidate who the state has directed. And this is a unanimous opinion from the United States Supreme Court, 9-0. 9-0, electors can be forced to vote as the state may direct. So that was easy. 9-0. No problem. Everyone's on board. Got that one right. Yeah. And presumably absent the cruel and unusual penalty clause, you can actually put in any sanction you want. And therefore, making it a crime and putting people in jail for fairly long periods of time would be constitutional. There is some suggestion that there is some proportionality to cruel and unusual, but if a state out there wanted to make it a 10-year felony or a 20-year felony, they could probably do it. So far right now it's just a monetary fine. But if states want to make it so they can force you to vote a particular way. If you vote a different way, they can remove you, put someone else, make them vote a particular way, and still sentence you to jail. So it's all for naught. You go as your elector, you go and cast your vote against them. They can disregard the vote, they can substitute you for someone else, and then they can put your butt in jail for 10 years. If they're so inclined. There are no limitations here, guys. So that makes total sense. 9-0. Easy. Yeah, capital punishment is out. But, yeah, 10 years in jail sounds fine. That was written by Kagan. Kagan is the next most junior. So, yeah, we're still in order. So Kagan's the next most junior, right? Yeah, I think that's right. So, yeah. Yeah, and a faithless elector is a felony. They wouldn't be able to vote in future elections either. That's a good point. A lot of states prevent felons from voting. So, yeah. So they can back it up. So it'll be interesting to see. It'll be interesting to see if states rush into any laws, right? Because we do have an election coming up in November. So how fast can the state legislatures pass laws? We might find out. No, treason is out because treason is specifically defined in the Constitution. You can't do that. Sedition is out because no. So no. But you don't need to do any of that. You can just define a completely new crime. You don't need to do any of that. You just define a new crime. It's malum in prohibitum, no problem. We just define a new crime. The crime of voting against the electoral college. Easy. I can write the statute in my head, no problem. Any person who knowingly casts a vote in the electoral college for other than as the state may direct shall be fined or imprisoned or both, and blah blah blah, no problem. So we have five more cases that apparently are to be decided, And we have plenty of justices yet to decide them, so we'll see what's going on. The state would be directed by law, so it would be the legislature or whatever. Yeah, it would be a law. So the way the electoral colleges would be directed is by law. So there's laws in the books that direct them to do certain things. So they would pass a law. That's how they do it. And then presumably you'd give an official the power to enforce that, which would presumably be the Secretary of State, because they're the one that typically makes the reports to the U.S. government. So presumably, or maybe in some states, depending on the nature of the law, you might be able to do it by regulatory fiat. But when it comes to criminal law, I'd recommend going the legislative route. So, are we done for the day? Are we already done for the day? Are we not? We're not doing any more. If we're done for the day, then I'm gonna go back and reread the one dealing with the robocalls and try to figure out what the law is. Yeah. So I'll get back to you on that. Yeah. Again, if no problem, if a state by law directs its electors to vote in line with the national popular vote, then exactly the state has the power to make the choice. The state the state can choose any mechanism it wants. Theoretically, voting itself is optional. They don't even have to do it by vote. They could just do it by the legislature themselves making the appointments. So yes, if a legislature passed a law saying that you must cast in a line with the national popular vote, then presumably that would be lawful too. So yeah, the National Popular Vote Compact has his own constitutional issues because it's an interstate compact and Congress might have to approve it. But yeah, a state could at least unilaterally do it. So there's that. Steve A says 8 in favor of banning robocalls, 1 in favor of allowing all robocalls. Yeah, I'm gonna have to go through it. I'm gonna have to count votes. So we're gonna have to count votes. But my favorite justice on the court right now is Gorsuch. So we still have 5 to go, and we still have more days, man. Jeez. So I'm gonna have to retitle the stream. I'm gonna have to retitle the stream. Still no word on location of Tulsa. Yeah, I don't know. The eternal question remains a question for at least one more day, man. I love how other people in my own chat are trying to explain to me what the holding of the case is. You know, I'll get back to you guys on that. It looks like we're done though. I'm just waiting to see if we're done before I get into a more in-depth discussion, because if I'm going to go into a deeper one and try to figure out what's going on, then I'd like to not be interrupted by, oh, by the way, we have an announcement in another case. So I'm just giving it a minute before I transition back to discussing the robocalls in depth and actually trying to count votes. So we'll get back to you. So it looks like we're just waiting on a calendar update. So it looks like we're done. That's annoying. All right. So we'll just go back to this and we'll try to count votes. All right. So Kavanaugh, Chief Justice Alito, and Thomas. Kavanaugh, Chief Justice, and Alito, and Thomas as the parts 1 and 2. So Thomas didn't join other parts other than 1 and 2. So, oh my God. Counting votes. How annoying. All right, so we have Congress pass a law. A leading senator wanted to do this. They prohibited robocalls to phones. They put in place this amendment. They carved out this restriction, put in these penalties. Plaintiffs in these cases are some people. They believe they want to do outreach. They are prohibited. Filed declaratory judgment. They argue it's content-based restriction and strict scrutiny, but the court concluded it survived strict scrutiny. The U.S. Court of Appeals vacated, say it didn't survive strict scrutiny. The court petitioned a writ of certiorari. Between this, we grant certiorari. How do we not get 9 votes for part 1? That's just a how did we get here? How do we not get 9 votes for these? This is how we got here. But whatever. We have 4 votes for this is how we got here. All right, pressing on. Now we got to talk a little bit about the First Amendment. Talks about content-based laws are strict scrutiny. Content-neutral laws are lower level scrutiny. Robocalls have exempted calls for debt. Is this content-based? The answer is yes. So if 4 people say it's content-based. It's relevant here. A regulation draws a distinction based on message. That distinction applies to the law that singles out specific matter for differential treatment. Law banning the use of soundtracks for political speech and only political speech will be content-based, even if it places no limits on political viewpoints. Fair? Under the law, the legality of the law turns on to whether it's made solely to collect debt. Robocall depends simply on whether the caller is engaged in political economic activity. We disagree. Singles out because debt collection speech to regulate the speech. In short, the robocall restriction is content-based, blah, blah, blah. Now part 3. Now we only have 3 votes for this. So we have 3 votes for this proposition. Jesus Christ. Having concluded that the 2015 creates this exception, we must decide to invalidate the entire restriction or instead validate the government debt exception. Right. Okay. Before we apply the ordinary severability principles, we must address the plaintiff's broader for why the entire 1991 call is unconstitutional. Plaintiff correctly points out the government interest for 91 calls consumer privacy, but according to the plaintiff's willingness to enact the government debt exception betrays a newfound lack of genuine concern for privacy. As plaintiffs phrase it, the exception undermines the credibility of the interest in privacy. I don't know about that. It just undermines them being hypocrites, but whatever. The argument is not without force, but we ultimately disagree. It's true that Congress has recognized exceptions diminished credibility for the rationale, but here the addition does not cause us to doubt the credibility. After all, the government debt exception is only a slice of the overall landscape. This is not a case where restriction on speech is layered with exceptions that substantially negate the restriction. On contrary, even afterwards, blah, blah, blah. The simple reality is we says has compelling interest, blah, blah, blah. Therefore, we disagree with the broader argument that the entire thing is invalid. So 3 votes for just the exception is invalid, not the whole thing. Okay. Ordinary severability principles. To invalidate this, we agree with the government must invalidate the government debt exception. Okay, so 3 votes to eliminate the exception. Great, that's easy enough to count. Then we get some rationale for why that's good. Blah, 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 blah. We cite Marbury for some reason, because why not? We have severability, blah, blah, blah. Before severing, it must determine whether or not we're capable of doing that. I see no reason why we can't. It operated before, so there's no reason why we can't sever it, because we're just like basically undoing a particular amendment. So that's easy enough. It seems, yeah, we can do that. So we apply these severability principles, blah, blah, blah. Some other stuff, some other things, some precedent that tells us we can do this. We would sever it anyway. One final wrinkle remains. This is an equal treatment case, and equal treatment cases can sometimes pose severability. The First Amendment is like an equal protection clause for ideas. I like it. Congress violated the equal protection in principle by doing this. When a constitutional violation is unequal treatment, the court can theoretically cure the unequal treatment either by expanding the benefits or burdens to the exempt class or by nullifying. Yeah, so we could fix this. We can fix this one of two ways, right? We created an exception that's invalid. So we can do one of two things. We can kill the exception or we can give the exception to everybody. So that makes total sense. If we want to fix this, we can kill the exception or we can give it to everybody, because either way would fix the problem. That makes total sense. The government would prefer to cure the unequal treatment by extending the restrictions and thereby prescribing all robocalls to cell phones. Me too. I'd also like that. Yes, let's just kill the exception so it doesn't apply to anybody. Yeah. No robocalls, lives matter. Yeah. By contrast, the plans want to cure the unequal treatment by nullifying the restriction so it applies to everybody. Apparently, they want lots of calls on their cell phone. Jerks. When, as here, the court confronts this problem, generally applies the same common sense principles. If a statute contains severability, the court severs the discrimination exception, blah, blah, blah. To be sure, some unequal treatment cases can raise complex questions about whether it's appropriate to extend or nullify. Some stuff about whether or not it would be difficult in a different case. Plans insist, however, equal treatment is different. Courting should not cure by outlawing more speech. Maybe, but not this time. General applicable would be fine, so that's all great. Gus's Gorsuch will state Supreme makes important points that warrant respectful response. So we're going to talk a little bit about what other people have said. I don't really care about it. Some other stuff, blah, blah, blah. Okay, so we have 3 votes. We have 3 votes for let's get rid of the exception and not apply it to anybody. All right, that was easy. Justice Sotomayor. I agree with the partial dissent's explanation. Strict scrutiny should not apply to this restriction. In my view, the government debt exception still falls in intermediate scrutiny because it's not narrowly tailored to serve a significant governmental interest. So she thinks intermediate scrutiny, even though it's content-based, presumably because it is commercial in nature or something. Whatever. It's seriously under-inclusive because of this. The government could have employed far less restrictive means. So nevertheless, I agree it's severable. With those understanding, I concur. Okay, so that's a 4th vote to sever. Okay, we've counted to 4. We've counted to 4 to sever the exception. Justice Breyer, Ginsburg, and Kagan, please say sever so that I can get to 7 and stop reading. A federal statute forbids, with some exceptions, making these calls. This case concerns one of these. A majority of the court holds the exception violates the Constitution. In my view, it does not. Is that votes to sever or not? We think it's cool. I don't know. I don't have to figure that one out. So 3 people say, no, this is totally fine. No, this isn't a First Amendment problem. So far I've got 4 to 3. Okay, that's great. Some other people say some other things, some other stuff. Blah, 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 blah. Yeah. So this is commercial speech. It doesn't violate the Constitution, so that's totally fine. No problem. Blah, blah, blah. I would find it does not. Okay. For the reasons described, I would find the government debt exception does not violate the majority of the court, however, has concluded the contrary. Okay, let's go with that. It must be decided that whether the content is severable. As to that question, I agree with Kavanaugh's conclusion the provision is severable. Accordingly, I respectfully concur in that part. Okay, great. We counted. We successfully counted. And we counted, I think we got to 8. Actually, because they refer to Kavanaugh. Or was Kavanaugh in the majority? Did Kavanaugh write this? Kavanaugh did write this. Okay, so we got to 7. Okay, so we got to 7. So we've severed the exception. Okay, so robocalls remain illegal. All the robocalls are illegal. All the robocalls to cell phones are illegal. Debt collection or not. I've successfully counted to 7. Yes, I've successfully counted to 7. I have a majority of the court that says I can sever this provision. Great, no problem. So the remainder of the law remains valid. The exception is invalid. So no more robocalls to cell phones for anybody. Huzzah! I have counted to 7. That was fun. Yay. Justice Gorsuch, the provision violates the First Amendment. Respectfully, I disagree about why and what the remedial consequences should follow. So he thinks it's unconstitutional, but he thinks the whole thing is, he wants to strike the whole thing down. Okay, so that's one other vote. And also implicitly, if we're striking the whole thing down, it's also a vote to strike down part of it. So there's that too. So I got that going for us. So Gorsuch over here wants to strike down the whole thing. No, please, God, no. I love you, Gorsuch, but no, I don't want robocalls on my cell phone very much. Thank you very much. Doubtful to rewrite the way, so he's doubtful about that. Wants to leave it to Congress to fix. But we're striking a particular amendment, so we're not even like striking. It's not part of like, it wasn't part of the law the whole time. It was added on, so we're just striking down the add-on, which seems a little bit easier than striking down part of the thing that existed the whole time. So like the severability is more implied because the law functioned just fine without the amendment. So I think Gorsuch goes a little bit overboard here. I understand why, like he's going this way, but it seems a little much, right? This philosophy would make more sense. Not that I'd agree with it necessarily, but it'd make more sense if it was part of the law the whole time. Congress passed it as a contemporaneous whole. They wanted the whole thing, and removing part of it is going against Congress's intent. So that makes more sense. But it wasn't that way. It was all robocalls were bad, and then later, oh, by the way, not these particular robocalls. So all we're doing is striking down the amendment. We're not striking down the whole thing. So the severability is implied, and also the ability of the other thing to survive on its own is implied because it did. Congress wrote it that way the first time. So like Congress obviously is okay with that because they wrote it that way. And then they wrote an amendment that's invalid. So, but they're obviously okay with the original. So I think Gorsuch goes too far. So yeah, Gorsuch wants to go to congressional intent or something, and I think he goes too far. So he agrees. Yeah, and he just thinks it's not severable. Cool. And Justice Thomas, where's Justice Thomas over here? Is Justice Thomas part of this, or is he like MIA? Did he not sit on this case? No, Justice Thomas joined as the parts 1 and 2. He just didn't write a separate opinion for some reason. So Justice Thomas is kind of MIA. Kavanaugh wrote the decision and delivered the opinion, which Roberts, Alito, and Thomas joined as the part 1 and 2. Sotomayor filed a current opinion concurring. Breyer filed an opinion concurring. Gorsuch filed an opinion concurring and dissenting in part, which Thomas joins as the part 2. So Thomas is over here in part 2 of the dissent. So what did Thomas have to say? Because he's hijacking Gorsuch's opinion. So Thomas says the question turns to remedy. So preventing the law's enforcement pursues the severability. I'm doubtful about severability. So Justice Thomas over here wouldn't sever either. So okay, wow, I'm so confused because justice was in part 1 or 2. So now I have to go up to now I have to figure out what Thomas thinks because I hate myself or something. So I have to figure out what Thomas thinks. First Amendment is good. It's a content-based restriction. Argues legislation depends on color. It's content-based. Singles up this speech. Subject to strict scrutiny. So, all right. So, I guess the best way to categorize this is 7-2. That seems the best way to categorize this as a 7-2 decision. Yeah, that's the best way to categorize it. So we've got 4 votes for. We've got 4 votes for it's unconstitutional, but we can sever it. We got 3 votes for it's constitutional, but we can sever it. And we've got 2 votes for it's unconstitutional and we can't sever it. As best as I can count. So that makes it 7-2 by my count. So yeah, we'll make this a 7-2 decision. So robocalls are illegal, and you don't have to worry about robocalls. So we have successfully navigated a complicated decision, and we have successfully got everyone on the right side of the page. So yeah, we've got 4 votes for unconstitutional, but it's severable. 3 votes for it's constitutional but severable, and 2 votes for and 2 votes for it's unconstitutional and non-severable. Yeah. Okay. Yeah. Okay. Great. Excellent. Fantastic. We have successfully counted to 5. Great. That was fun. All right. Let's going on here with let's go back to SCOTUS blog and figure out what's going on here. A whole lot of nothing. So SCOTUS blog apparently has no further information to share. That's helpful. Thank you, SCOTUS blog. Oh no, we do have some more stuff. Thank God. So let's see what's going on here in the last 20 minutes. It took me to figure that out. So this is the last place we left the action. So let's see if they have anything to add to me. Okay, so we just don't have any information right now about what's happening. So I don't know if we'll be back tomorrow or not because they don't want to tell us anything. But I'm going to rename this stream. So we will rename the stream because it is no longer about where's Tulsa because we still don't know the answer to that question because that's not important. There we go. That's better. We still don't know where Tulsa is. And we have apparently no further information about when decisions will be released because that's not important information. The robocall ban is enforced by the various penalties. They're enforced by the FTC principally, and they can also be enforced by private action. And the FTC does go after people, and they get some fairly large awards. So, and also there's that new thing which is called something stupid, like something stir. What's called I forget what the other half of it is called, but it's called something stir, which is supposed to be this new authentication to help prevent robocalls. So I don't know. But there's some pretty serious fines the FTC can put in place. How effective that is, well, they try. Shake stir, that's right. It's called shake stir because it has to be something stupid. I knew it was something stir. I couldn't remember what the other half of it. Yeah, it's called shake stir because I don't know, because we're idiots. Yeah, that new authentication thing that's supposed to help prevent robocalls that they're trying to roll out. Shake stir. Yeah. All right. Well, unfortunately, we do not get to find out where Tulsa is today. So we only got 2 decisions, and we still have, I think, 5 more. When will we get our next 5? I have no idea. And don't ask me questions like that. How do I know the answer to these questions? I don't know. I just read and interpret decisions, and then sometimes I have to count votes. So that was fun. So that was Yeah. So that was super fun. If you liked this, for the how many of you are currently watching? For the 90 of you who are currently watching, first of all, thank you. I'm very thankful for the 90 of you who are currently watching that you've chosen to spend some of your time with me. It feels validating. I'm starting to get these streams where I'm starting to get like, 90 or 100 or 110 people, for these streams. So it feels like I'm really making some progress. So first of all, thank you for being here. Your presence is super appreciated. I really, really validates me. Thank you. If you liked this stream, if you'd give it a like, it will help. And for those of you who particularly like the stream and like my content, you can become a member of the channel. For 99 cents a month, you too can get your name in green and be a member of the channel. Somewhere on your screen, somewhere where the subscribe button is or should be, there should be a join button. If you press that join button for 99 cents a month, you get your name in green. Now, someone asked me, will you have support beyond YouTube at some point? Yes, probably. At some point, I have opened a subscribe star account. Not that I'm using it right now and I'm not promoting it, but I've opened it just to like have it as a thing that exists. But at the moment, I'm not promoting it. There's a couple reasons for that. First of all, I feel like people giving subscriptions inside YouTube has got to be helpful for the promotion of the channel, right? If I get more people who are members of the channel, first of all, YouTube gets a fairly sizable cut of that, and they get 30% of that. And I feel that that would make them more likely to promote this content and recommend this content and less likely to demonetize it. It's a guess, but I'm just guessing that YouTube likes money. And so I'm guessing they look at membership support rates as a mechanism to determine whether or not channels should be recommended. So therefore, that's one of the reasons I'm promoting YouTube as a subscribe means. It's obviously not getting me as much money as if I went through a different channel like Subscribestar, where instead of a 30% cut, it'd be more like 5%. So I get a much bigger share of my revenue. But right now, to help the channel grow, it makes way more sense to promote things from inside YouTube. So that's why. Also, incidentally, if I do something on Subscribestar, then presumably I have to figure out like what reward tiers are. And I have to figure out what the rewards for those reward tiers are. And I don't really know what those would be. What am I giving for what kind of money? I don't know. So that is something yet to be determined. But anyways, yeah, if you'd like to join, that would help. $5 from Big C Burger. Join us next time for Where's Tulsa, maybe, or any other decision they feel like releasing. Pretty much, yes. $4.99 from Stephen Fotis, all for the hat. Well, thank you very much. It's appreciated. So that's what's going on. Also, for those of you who are interested, I'm experimenting with a Discord. I'll give you the link for that. You can come on board and check that out and so forth and so on. Hold on. There you go. So you can check out that Discord. It's a way to, just something we're kind of experimenting with right now. But there's nothing else for me to do right now. So for all those of you who are here and enjoyed it, thank you very much. And until later, my friends, cheers and goodbye.